Hi everyone, welcome to SQE1 window and we start our chapter 5. This is where everything comes together. We are covering the duties and powers of personal representative, the practical process of state administration and claims that can be made against the state under the 1975 Act. So the chapter is absolutely important for SQE1 because it is tested quite often in our MCQs. So who are personal representatives? So let's start with the basics. Personal representative, or we name it as PRs, are the people who administer the deceased estate. There are two types: executors, who are appointed by a valid will, and administrators, who are appointed when there is intestacy or when no executor can act. Both must obtain a grant of representation from the probate registry before they can properly deal with the estate assets. Their authority is the same: collect asset, pay debt and taxes, and distribute what remains to the entitled beneficiaries. The key difference is the source of their authority. Executors derive it from the will, administrators from the grant itself. Remember this distinction because it affects, timing and power, when they can start, how they can deal, and all, and what are the powers. So powers of PRs, personal representative powers, are derived from two sources: statute and will itself. For testate estate, the will may extend or restrict the statutory powers. So the testator might give executors additional powers to invest, carry on a business, or postpone sale. For intestate estate, personal representative have implied statutory powers set out in Administration of Estate Act 1925. Here is the crucial point: PRs, personal representative, must act within their powers to avoid personal liability. If they exceed their authority or act improperly, they can be held personally liable for losses to the state. This creates a careful balance. They have broad powers to administer effectively, but they must exercise those powers properly and within legal limits. So, key powers of personal representative. First, the power to insure estate properly. This comes from the Trustee Act 1925 and 2000. Personal representative can take out insurances to protect estate assets from loss or damage. This is particularly important for valuable property like houses or collections. Second, the power to sell assets and raise money. Section 39 of Administration of Estate Act 1925 gives PRs power to sell property to pay debts, funeral costs, administration expenses, and taxes. They can sell assets even if beneficiaries object, provided the sale is necessary for proper administration. Third, the power to appropriate assets, transfer property directly to beneficiaries in satisfaction of their entitlement. Section 41 of, once again, Administration of Estate Act 1925 permits this. Rather than selling everything and distributing cash, PRs can transfer the family home to the spouse or give shares directly to children, provided value are fair and beneficiaries consent where required, at that point. So renunciation and reservation: executors don't have to accept their appointment, so it is not inflicted. They can renounce their executorship by deed filed at the probate registry. Renunciation must happen before they take any step to administer the estate, before intermeddling. Once you renounce, it's irrevocable. So there is no U-turn. So power reservation is different. An executor can step aside temporarily whilst retaining the right to act later if needed. This is useful when multiple executors are appointed, but only some act to some of them they want to act immediately. There is also the chain of representation. If the last remaining executor dies whilst administrating the estate, their executor automatically becomes executor of the original estate. I will repeat this. If the last remaining executor dies whilst administering the estate, their executor automatically becomes the executor of the original estate. This creates a chain that avoids gaps in administration. However, if the chain breaks, perhaps the executor dies intestate, a grant D bonus non is required. This is a special grant allowing new administrator to complete the administration. For your exam, know when each mechanism applies. Now, look at duties of personal representative. What personal representative must do? Their first duty is to collect and safeguard all estate assets. They must identify everything the deceased owned and secure it. Second, they must pay all debts, legacies, and taxes, then distribute the residue to entitled beneficiaries in the correct order and amounts. Third, they must prepare state accounts showing all assets received, all payments made, and how the estate was distributed. These accounts are provided to residuary beneficiaries for approval. PRs must act with due diligence and in the best interest of beneficiaries. They owe a fiduciary duty, the highest duty recognized in law. This means complete honesty. So what is complete honesty? Along with honesty, they must be loyal and acting only in beneficiaries' interest, never their own. Crucially, beneficiaries have no right to specific assets until administration is complete. They merely have right to have the estate properly administered. This protects PRs from premature distribution demands and all. So, breach of duties and liabilities that haunt. What happens when personal representative breach their duties? There are three main types of breach: negligence in administrating the state, maladministration by failing to follow proper procedures, and misappropriation of assets, using estate property for personal benefit. So PRs are personally liable for breaches if they wrongly distribute assets and there is not enough left to pay creditors or other beneficiaries. They pay from their own pockets. This is serious personal financial exposure. So what about co-PRs? If you are one of the multiple PRs, you are only liable for breaches if you were aware of them or facilitated them. This comes from Williams versus Nixon. You are not automatically liable for anything your co-PRs do, but you must exercise reasonable supervision. We talked about it before as well. The Trustees Act 2000 imposes a duty of care. The standard depends on the PR's knowledge and skills. Professional PRs, like solicitor, are held to higher standards than lay PRs. However, Section 61 of the Trustee Act 1925 gives courts discretion to relieve PRs from liability if they acted honestly and reasonably and ought fairly to be executed. This provides some protection for honest mistakes done by the PRs. So, protection for PRs once again. Fortunately, PRs have important protection against liability. The most important is Section 27 of Trustee Act 1925. PRs can advertise for creditors and beneficiaries, and if they wait at least 2 months after advertising before distributing, they are protected from unknown claims that emerge later. The advertisement must appear in London Gazette and a local newspaper circulating in the area where deceased lived or owned property. After 2 months, if no claim comes, and PR can distribute safely. This does not stop claim being made against beneficiaries who receive assets, but it protects the PR personally from liability. Still, people can go against those who inherited, but not the PRs. PRs should also conduct searches, land registry searches for property, land registry searches for secured debts, and bankruptcy searches to check if the deceased was bankrupt. For known but missing beneficiaries, PRs can apply for Benjamin order. And that Benjamin order is issued by court. These orders authorize distribution on the assumption of missing beneficiary is dead. Alternatively, PRs can take out insurance, obtain indemnities from beneficiaries, or retain a reserve fund to protect against the missing person appearing later. These mechanisms balance the need to distribute the estate with the risk that someone might have a claim. So Keep in mind the Benjamin order that we have talked about. That Benjamin order is, I've seen that in exam. So let's talk about the practical process. PRs must discover and secure all assets properly. This means like collecting all information, contacting banks, tracing investments, securing property, and collecting debts owed to the deceased. So, estate funds should be held in designated bank account or solicitor account, never mixed with personal funds. PRs must pay debts, funeral costs, and administration expenses before making any distribution to beneficiaries. This priority is fundamental. A major practical challenge is funding inheritance tax. So inheritance tax is due 6 months after death of deceased. But the grant is needed to access most assets, and you need to show inheritance tax is paid or arrangement made before the grant is issued. So how do you pay tax on assets you can't access? There are several solutions. Using the deceased own funds if accessible, utilizing small payment provisions for bank release amount for IHT, inheritance tax, taking loans secured on estate assets, or asking beneficiaries to contribute with later reimbursement. This circular problem is common in exam topics. Most of the time they give you option that you can get an advance from bank. So, choice of asset and debt. PRs have discretion in choosing which asset to sell and which to transfer directly to beneficiaries. Assets are only sold if necessary. There is no requirement to convert anything to cash. When deciding, PRs must consider the will's provision beneficiaries, which is asset values and liquidity and tax implications. For debt, there are two categories. Secured debts, like mortgages, are paid first from the charged property. If I die with a mortgaged house, the mortgage is paid from the house proceeds before anything else. Unsecured debts follow statutory order, and that is set out in Administration of Estate Act 1925. For insolvent estates where the debts exceed assets, the Insolvency Act 1986 applies with strict statutory order. Funeral expenses and administration costs come first, then preferential debts, then ordinary unsecured debts. Understanding this hierarchy is crucial because it determines who gets paid when and is not enough to go around. This frequently appears in exam, that who is left out and who will get the money. So distribution follows a strict order. Specific legacies are paid first. Gifts of particular items, for instance. Then pecuniary and general legacies, cash gifts and general entitlement. Finally, the residue is distributed to residuary beneficiaries. PR must correctly identify beneficiaries. This involves applying the covariant rule for simultaneous deaths, identifying members of class gift, and determining status of adopted and illegitimate children who are treated equally under modern law. PRs must ascertain each beneficiary's entitlement. Is the gift vested, unconditionally theirs, or contingent on a condition, for example, like reaching an age of 25? This affects timing and risk. For land transfer, written assent are required. An assent is a document by which PRs formally transfer legal title in land to beneficiary. It must be in writing and should be registered at the land registry. For personal property, assent can be informal, but written assent provide better evidence and protection. Getting these formalities right is essential for proper administration of estate. So I hope it works and bear with us. So estate accounts and finalization. An administration near completion. PRs must prepare comprehensive estate accounts. These include capital account showing all assets and their values, income account showing income received during administration, and distribution account showing who received what. These accounts must be approved by residuary beneficiaries. They are entitled to see exactly how the state was administered and to verify they have received their correct entitlement. PRs must calculate and pay all final taxes, any additional inheritance tax, capital gain tax on asset disposal, and income tax on estate income. Before making final distributions, PRs should obtain an HMRC discharge certificate confirming all tax liabilities are settled. Distributing before getting their clearance is risky. If additional tax emerges, PR may be personally liable for that. Once accounts are approved, taxes paid, and discharge obtained, PRs can make final distributions and close the estate. Proper record keeping throughout is essential. Keep all receipts, valuations, and correspondence. These protect PRs if questions arise later. Okay, family and dependent claims. Now let's look at claims against estate under the Inheritance Provision of Family and Dependent Act 1975. This act allows certain people to claim financial provision from the estate if the will or intestacy rules did not make reasonable provision for them. Who can claim? Surviving spouse or civil partner, former spouse who haven't remarried, children of the deceased, including adult children, anyone treated as a child for the deceased, persons maintained by the deceased before the death, people who were financially dependent, and cohabitees who lived with the deceased for at least 2 years before death. This is the only way cohabitees can claim. So remember, they have no automatic intestacy right, and they can make a discretionary claim under 1975 Act. The process requires applying to court within 6 months of grant of representation. The court assesses whether reasonable financial provision was made. If not, the court can order provision from the estate. This 6-month deadline is crucial. PRs should wait before making final distribution to allow time for potential claims. So what is court consideration? How court decides these claims? They consider general factors applying to all circumstances: the applicant's financial need and resources, their obligations and responsibilities, any physical or mental disabilities, the size and nature of the estate, and moral obligation of deceased. For surviving spouse, court apply a generous standard similar to divorce provision. They are entitled to what's reasonable in all circumstances, which is often substantial. Former spouses get more limited provision, typically only maintenance. Adult children face a higher bar. They must show special circumstances. Simply being a child is not enough. They might need to prove financial dependency, disability, and that the deceased had assumed responsibility for them. Cohabitees must prove they lived with the deceased for 2 years before the death and had a genuine maintenance requirement. The standard is lower than for spouses but higher than for strangers. If the court found for the claimant, decided for the claimant, it can order various remedies: lump sum payment, periodic payment for maintenance, property transfer, or variation of ante-nuptial or post-nuptial settlement at that point. The order is designed to achieve reasonable financial provision, not to rewrite the will entirely. So only to correct things, only to help people who are just left out. SQE tips and pitfalls, and let's finish with targeted exam tips. First, memorize the key statutory references because they appear constantly, like Section 25 sometime or Section 39, the power to sell and all. And remember Section 27 notice and Benjamin order. These protect PRs from against unknown or missing claimants. So these kind of questions, they appear there. Understand the order for paying debts, secured debts from charged property first, then unsecured debts in statutory order. Know that insolvent state follow insolvency rules, and that's an order of distribution we need to understand. For distribution, remember the order: specific legacies first, the pecuniary legacies, then the residue. Don't confuse this with payment of debts. Critical point: PRs should wait 6 months after the grant before making final distribution to allow time for family provision claims under 1975 Act. Distributing earlier risks having to recover assets if a claim succeeds. Common pitfalls are confusing PR's power with trustees' power, or mixing up Section 27 protection with Benjamin order. Both of them are two different things. So, once you approach the question, hold on, just have a holistic view of wills and administration of state, and start deciding on options. I wish you all the best. Ta-da!